I thank you all so much for attending. I feel so sad that I can't see you. I like to see everybody and get an opportunity to say hello and find out if you're all doing okay. So I hope everybody is doing all right. As I said just a minute ago, there is a chat box. And so if you can find that on your screen, then go ahead and you can use that so we can answer questions, or Sarah can answer administrative issues that you might have. If you're having trouble in some way and you need to contact the office, just give us a call at 480-348-1590. We are also recording this, and so we should have that on our website and hopefully on Facebook as well, so that if you feel like you missed something or you want to share it with somebody who was unable to attend, you can let them know that as well. So again, thank you all for joining me. I feel sad I can't see you, but I know you're out there, so thank you so very much for your interest. And I hope that you can gain some information that maybe you didn't have when we start this. For those of you who don't know me, I'm Emily Kile. I'm a partner here at Kile and Kupiszewski Law Firm, and we're in Scottsdale, just off the 101, if anybody drives anywhere anymore. So I hope you and your families are safe. Estate planning has become something that I think people have found to be even more important or urgent than maybe they thought that it was. I've heard a lot from clients that this has been on their to-do list, on their bucket list, on their New Year's Eve resolution list. And it's only now that they've decided to take it seriously and sit down and try and figure out what they need to do in order to make sure that their wishes are followed. So for lots of you, maybe you already have an estate plan, and this is your opportunity to kind of look at it and update it and make sure that it still meets your needs. So that's what we're here to kind of talk about, the differences between wills and trusts. The main question that I get when clients come in is, do I need a will or do I need a trust, and what's the difference? And so this isn't really the perfect graphic, I suppose, but it's just meant to get you thinking about what is that estate plan going to look like, and understanding that an estate plan is more than just your will or your trust, but that is part of the foundation of your plan, right? We have other documents like powers of attorney and healthcare directives or living wills or do not resuscitate orders. And all of that makes up your actual estate plan. But today we're going to focus on the will and the trust. So in part, maybe part of your decision tree is, well, how much do I have? Do I want to have a probate? Do I want to avoid a probate? Is there some other process that might be out there? If I have a trust, are my assets actually titled in the trust? And have I set things up so that I will avoid probate, which is one of the main reasons why people want to do trusts. So super important to make sure that you're thinking through what are those issues. So property that's jointly owned probably goes to the joint owner. So if you have a bank account and your spouse is named on that bank account with you as a joint owner, when you pass away, the money will all go to the person who's listed as the joint owner. I've had clients who have said, well, I want to put my child who lives locally on as a joint owner on the account to make things easy, and so they'll have immediate access to cash if something were to happen to me. And that's completely fine, but just remember that you've made them an owner. So even if your intent was for them to use that money for you, it might be that they take the money and they use the other money in the estate to take care of you or to pay the debts of your estate. So an owner's an owner. Additionally, in the event that that other person ends up in some kind of a lawsuit, a car accident, maybe outside of policy limits, or a divorce, you may have put some of that account at risk by making them a joint owner on it versus a signer on the account, or a beneficiary. So when you pass away, they would get the money. So you're making a plan by adding them on to be a joint owner. Now we have other assets like real estate, where if you just say you're joint owners without the words with right of survivorship, in Arizona, that probably means we're going to have to probate half of that property when the first person dies. Because for real estate, you have to accept that right of survivorship, that joint tenancy that continues on so that the other owner would get the whole property. So very important for real estate to make sure those extra words are on there, the words that say with rights of survivorship. That is crucially important to make sure it's going to go to the survivor. Maybe you don't want it to go to the survivor. Maybe you want it to go to somebody else, or you want it to go through probate. Well, then just as joint ownership is fine. And people think just because you're married, it will go to your spouse, even if it doesn't say with rights of survivorship. And the answer is, well, it might end up there, but we still are probably going to have to probate or do some process in order to transfer that other half of the real estate. And also remember that if you have a joint ownership, no matter what you said in your will is not going to control that. So if I have Sarah as a joint owner on my bank account and my will says that everything goes equally to my nieces and nephews, Sarah's going to get that account because she was a joint owner on it, even if she's not a beneficiary under my will or under my trust. I've named her to get that other part if it's joint or real estate that's joint with rights of survivorship. So just be conscientious about how things are set up. Sometimes the banks don't set things up exactly the way you ask, so you might want to confirm that. So I actually had this conversation with a client this morning. When we talk about beneficiary designations, I think it's kind of a confusing way to put it. So I apologize. There are really three basic categories of what I think of as a beneficiary designation. So pay on death or POD are mostly retail accounts. So we think about your checking account, your savings account, your money market account. All of those the banks say as payable on death. That means that when I die, whoever I listed is going to get what's in those accounts. Investment accounts are called transfer on death. Now, I don't know why somebody decided these had to be different words, but that's the way they set it up. So they mean the same thing, but they're called different things. And then you can have a beneficiary deed for real property. So that's a deed that gets recorded while you're alive that says when Emily dies, if I still own that piece of property, it goes to whoever I've listed in the deed. And you can list more than one person POD, TOD, or a beneficiary designation or on a beneficiary deed. So you could say 25% to my child and 75% to my grandchild, whatever you want. You could say 25% to my kid and 75% to charity. All three of those can work that way. The important thing to remember is a beneficiary deed must be recorded while you're alive. We can't record it once you're deceased and have it qualify as a valid transfer. And if you file or record that beneficiary deed with the county recorder, you can change it anytime you want. So if you decide that you don't like the beneficiary on there anymore, you don't need their permission. You can just record a revocation completely, or you can record a revocation and a new beneficiary deed and change who the beneficiary is going to be. The same is true with those payable on death or transfer on death. You don't have to notify the beneficiaries. Sometimes it's a good idea so that they know what asset to collect, but there's no obligation to do so. So you can change your mind anytime you want. You can also have a beneficiary designation on your life insurance or on your retirement accounts. And those, of course, are forms that are specific to that account. So you would need to get a specific beneficiary designation form from that life insurance company, retirement company, annuity company. They'll all have their own forms. For the POD, you typically do that directly at that financial institution. And for the TOD, your investment accounts, your financial advisor should be able to get you that form to complete as well. Beneficiary deeds, again, get recorded with the county, and so they're going to require a notary on those deeds in order to make them valid. As I said earlier about the joint tenancy, your will or your trust won't control what happens to your stuff if you've listed a POD, TOD, a beneficiary on those assets, because you've made a contract with that bank or with that investment firm, or a beneficiary deed, you've recorded the designation. And so again, if I said Sarah is POD on my bank account, but my will said everything goes equally to my nieces and nephews, she's going to get the bank account that she was POD on, and they're going to split the other assets, assuming they weren't held jointly or didn't have beneficiary designations on them. So again, sometimes you're making an estate plan when you don't even realize you've made the plan. So just be conscientious about that. So we have seen wills that turn out not to be valid, and that can be very disappointing, in part because we might end up with a probate, which again is not a big deal, but the outcome of that probate might be very different than if we had a valid will. So to be valid, if it's handwritten, and I mean completely handwritten, who you give your stuff to must be in your handwriting. You can get a form probably off the internet, but you need to handwrite in what they call the dispositive provisions. That's where your stuff goes, who gets your stuff, who your personal representative is. Kind of the customized part of a will has to be in your handwriting, not typed, not electronically completed, but in your handwriting. And in that instance, it doesn't require any witnesses, although you would want to make sure it's clear that it's your will, and you would want to make sure it's dated in case we find some other will and then we don't know which one came first. If it's not literally handwritten, pen to paper, then it requires 2 witnesses. We always have a notary as well, because that gives credence to the fact that it was actually you and it was actually those witnesses who signed. But it's not required under the statute, but you do need 2 witnesses if there's no notary. Again, you always want to make sure it's dated, because we might not know in time which happened first, or whether you made a codicil or an amendment to your will and then we find another will, we don't know which one's valid. Now, there's a lot more to a will. As I said, you'd want to name a personal representative. Sometimes in some states that's called an executor, but our statute calls that a personal representative. And you want to say whether they have to obtain a bond. Most of the time, we say that there's no bond required for the personal representative, because you've chosen somebody you trust, and we don't want them to have to go out and then spend money to get a bond, or have assets restricted without their ability to sell them so they can pay your debts and get your tax returns done and do all of the other things that that personal representative needs to do. So those are kind of the basics of making sure that your will is valid and so that your wishes will be followed. So what does your will actually do? Well, it's to control what happens to your stuff that's only in your name, that is the decedent, with no joint owner, no beneficiary designation, no POD, no transfer on death. And it also sets forth who's going to settle everything for you, who's going to pay that final tax return or make sure it gets filed, who's going to get your house sold, who's going to clean out your personal effects. All of those things are done by the personal representative, and your will sets forth who that is. You can also name a guardian of an incapacitated spouse, a minor child, or a disabled child in your will, or you can do it by separate nomination. So if you have kids that are minors, or again, an incapacitated spouse or a disabled child, we want to know who you would want to be the guardian and as an expression of your wishes. So you can certainly put that in your will, although as I said, you can also do that on a separate nomination form. So what does your will not do? So having a will has nothing to do with whether you're going to need a probate in court or not. It doesn't have anything to do with whether people are still going to be angry and file a lawsuit one way or the other over your estate or how your will was drafted or whether you had capacity when you wrote it. And all of your debts probably still need to be paid. But what it does do is it's an expression of what you want to have happen, which is really, really important. It sets forth who's going to take care of stuff and where your stuff goes. So if you have a kid you don't like and you don't want that kid to inherit from you, you need to have a will, and the will needs to say that that person is not going to inherit or their descendants are not going to inherit. Or maybe you have charitable intent and you need a will to say that the charity is going to receive those items. Or maybe they're going to receive the sale proceeds of your personal effects and the rest of your stuff is going to go to your individual beneficiaries. So it's very important to have a will. Now, the question of where's the original or do I only have a copy could determine whether it's an easy probate or a more timely and expensive probate. Really important in my view to make sure that the person who you've named in the document to be the personal representative is actually going to know where to find your estate planning documents. Don't hide them somewhere. Make sure you tell the personal representative, hey, I named you in my documents. This is where you can find them. If the bad thing happens, this is where the documents are. Here are copies in case the originals get lost. So if we have the original, we can do what's called an informal probate, meaning that we shouldn't have to go to court, although we have to file a bunch of papers and file the original will into the court system. If we only have a copy, we typically have to set that for a hearing and have the court determine that the copy is valid as if it had been the original. So the original of the will in all of your estate planning documents, that is the most important thing. Everything else, pretty much a copy is going to be just fine, but an original of your will is really important. So let's turn to what's a trust. So it is a whole lot of paper for sure. I like to think of the trust as the rule book for how your stuff is going to get managed. Now remember that a trust goes into effect from the moment that it's signed. So it's not only about death and disability, it's about you during your lifetime while you're competent to manage your belongings and your assets. When you become disabled, it's to put somebody in charge of following the rules in the trust. And when you pass away, for them to follow the rules for what happens to your stuff afterwards. So think of it this way. If I became disabled, but my trust said, I want my trustee to use the money to continue to pay for the education and support needs of my children, then the trustee would know that that's okay. Otherwise, if I just said, if I become disabled, all of the money is only for me and not for any dependent, then the trustee will not use that money for anything but me. So those rules are very important. That's what the trustee follows or should follow to make sure they're meeting their fiduciary obligations in managing that trust correctly. So who are the players? Well, we have the trustee who I've been talking about. That's the person who needs to manage your assets, pay your bills, meet with the financial advisor to make decisions about what investments you're going to have. That's you most likely during your lifetime and somebody else when you become incapacitated or pass away. And then I guess because lawyers couldn't agree on a term, we have the trustor, the settlor, the grantor, the trust maker, all of that, those words mean the same thing. It's who created the trust. Usually that's who put the money in, but not all the time, but it's who created the trust document. And then of course we have the beneficiary. And the beneficiary is the one who benefits from the trust assets. Again, that's going to be probably you during your lifetime. If it's an estate planning trust, a revocable trust, whatever you want to call it, you're the one who gets to benefit. Maybe it's you and your spouse who get to benefit. And as I've said, while you're alive, you control everything. So people sometimes get nervous about naming the trust as the owner of that bank account. But while you're the trustee, it's totally your money. Buy, sell, trade, give it away, do whatever you want, just like you do now. It's just that it's titled in the trust, hopefully. There's no new tax identification number for these kinds of trusts. Everything just gets filed under your tax ID. So there's no extra filing that needs to happen with the IRS. So I've just given you an example. When we talk about funding the trust or titling the trust, we're talking about what is the name on the asset. So if I have a bank account, that bank account needs to be in my trust. If the name of my trust is the Kile Family Trust, then the account is going to be Emily B. Kile, trustee of the Kile Family Trust. Or maybe it's just going to say Kile Family Trust on it. If you get your bank statements and they have your name followed by comma TTE for Tom, Emily, that would be for trustee. TTE stands for trustee. So maybe the trust name isn't on your bank account, but it says Emily Kile, comma TTE. That would be an indication that it is titled in the trust. If you need to make the trust the beneficiary of an asset, this is also the way you can set it up. Maybe I wouldn't use my name because it's going to pass to the new trustee because those funds are only going to go when I've passed away. So maybe it just says trustee of the Kile Family Trust, or maybe it just says Kile Family Trust. Usually that's also followed by the date that the trust was created. That's kind of a great way to make sure that it's different from every other Kile Family Trust out there as to when it was actually created. And you can title your trust anything you want. You could be the flower trust if you want it to be. It could be named after your dog. Whatever you want to call it is fine. Remember that it isn't going to change over time and it's going to be on your assets. So you probably don't want to have a trust name that's super duper long. So we usually don't have the trust name to be first spouse's first name, middle name, last name, second spouse, first name, middle name, last name, you know, and then the word trust, family trust, revocable trust, whatever it's going to be, just because it's super long and one of you is going to pass away first. But there's no prohibition to that. It's totally up to you. It's just a question of practicality. So the benefits of a trust are the assets that are titled in the trust will avoid probate because trusts don't die. So that trust will continue after I'm incapacitated and after I pass away. Then that asset, again, the trustee is going to follow the rules in the rule book, which is the trust document, to figure out what to do. So I don't need a court to help me with that because it's already in the trust. Banks and other financial institutions sometimes have trouble with financial power of attorney documents. Maybe it doesn't say XYZ bank account 1234 on it, and they want it on their own letterhead. However, most financial institutions and banks absolutely understand how trusts work. So if the account is titled in the trust, they're going to listen to the trustee. Now, they might need to see a certification of trust so that they know that you're really the trustee. They might want to see the whole trust document, but they're very likely to comply with the terms of that trust. Conservatorships are actions that we need to take when we have assets in an incapacitated person's name and nobody has control over that asset. So maybe we don't have a financial power of attorney and the person didn't have a trust. We might have to go to court and have a conservator appointed. This could even come up when you have a trust. First, you might have an IRA or a 401k or a 403b, some kind of retirement account, which are not titled in trusts, although trusts can be beneficiaries. And if you didn't have a financial power of attorney that somebody would follow, that asset won't be able to be managed by the trustee, so we might still end up in court. Or it might be that you have a trustee who everybody thinks is a bad person, and they go to court to have a successor appointed or a conservator to manage those assets, or you didn't title everything in your trust. And so then we have accounts that either need to go into the trust or are managed through that conservatorship. Typically, trust administration is a bit more private than doing a probate. We don't have to publish notice, for example, to creditors. We don't have to file anything with the court system, but we still have to give notice to the beneficiaries. They have a right to understand what their rights are and to get accountings so that they can protect their interests. So there's still notification, there's still administration, but it's usually more private. And it's much easier through a trust than through a will if you don't want your beneficiaries to receive outright distributions. So you could say they get 10% a year, or they get money at certain ages, or if they meet certain benchmarks in their lives. So you can put that complexity of the distributions into the trust, which is more difficult to do through a will, although certainly possible. So some common questions that we get related to trusts are there any tax issues? And most of the time the answer is no. If I create my own trust, it doesn't have a new tax ID number. I haven't changed the tax basis. I haven't done anything that would trigger a tax issue while I'm alive. If you have a small estate, it might be that you don't need a trust, or maybe you do. It's not really so much for tax planning all the time because the estate tax exemption is $11.5 million. So unless you have more than that, it's not really for tax planning. But it is an opportunity to control the distribution. So if you have minor children, you probably want to do a trust so you can make sure that somebody manages the money for those kids until they turn whatever age you're comfortable with. And maybe you don't want them to get it as an outright distribution at 18. Whereas if you had a probate and the assets are restricted until age 18, they're going to get everything when they turn 18. So it's an opportunity, regardless of the size of your estate, to have some control in how the distributions are made. Most of the time, the trusts are completely amendable and revocable, and so you can definitely make changes later. If you have a joint trust with your spouse, there might be some circumstances in which you've both agreed that you won't make changes. Maybe all the children are not in common to both of you, and so you want to say, hey, when the first one dies, the second one can't write out and disinherit my biological beneficiaries. Or I always want this person to be a trustee, or one person from my side of the family to be a trustee. And so you could put provisions in there, but you don't have to. It can be perfectly fine to be totally amendable and revocable. While you're alive and competent, if you've named yourself as the trustee, you have total control over those assets. As I said, buy, sell, trade, gift, whatever you want to do. If you have property outside the state of Arizona, you don't need a separate trust for that. You can have all of your assets that are in the US titled in that same trust. So if you're fortunate enough to have property on the beach in California, and a house up in the mountains and a beach house on the East Coast, all of that stuff can be titled in the trust. If you have mineral rights in the Midwest somewhere, or royalties, all of those things can be titled in your trust so that we can manage all of it the way you want it to. There really is no perfect right answer for everybody. You have to think through what's right for you. We certainly talk to clients who have had an experience, good or bad. Sometimes people have great experiences with trust and it's the only way they want to go. And sometimes maybe their sister, who they didn't like very much, was the trustee and it was a total nightmare. Sometimes that makes it so you can make more practical answers. If your kids don't like each other, probably them as co-trustees isn't going to work well. Maybe neither of them should be the trustee, because maybe one of them is going to be not very pleasant to the other one, and so that's going to turn into a fight all the time. Maybe you don't want your child to be the trustee because they have a younger sibling and it would be not very pleasant for them to control the distributions for their other sibling or other family members. So you have to decide, what works for you from a practical standpoint. Not everybody needs a trust. You have to decide, first, it's more expensive. So is it within your budget? And then does it meet your goals as to what you wanted to accomplish? But making some kind of a plan is super important. So we don't have to question what did you want, and hopefully so we can alleviate some of any controversies, because we have your intentions in your writing, signed by you when you were alive, telling us how you wanted things done. That's how you make your wishes known. Of course, it's really important that you talk to the people who are the decision makers and talk to the beneficiaries, because maybe we can solve some of the problems before they happen. You know, if you said to your kids, I'm going to give more to this child because they've, you know, supported me and lived with me and helped me through some really tough times, and I don't want you to be surprised by that later. Or maybe they're going to go, it's going to go evenly, and you need to say to the child who maybe has been more supportive, I just want you to know I'm treating everybody the same. I don't want there to be any fights later. Maybe you have some personal property that you want to go to a specific person, and so you want to make sure that that's on a list so everybody knows that you wanted it to go to them. Maybe you have a piece of real estate and you want your kids to be able to have the right to buy it first before it would go on the market, or for them to continue to share it. So you want to think through what those issues are and then make the right decisions. Certainly, if there are more complexities in your family, such as second marriages or special needs beneficiaries, those are going to really maybe make some determinations as to what makes the most sense so that we can comply with what the needs of your beneficiaries are. I've already talked a little bit about what if people don't get along with each other. And so we've got some difficulty that we want to make sure we put the documents together in a way that we don't make that even worse than it would be. As I said, certainly if you have property in more than one state, I think a trust usually makes sense so we don't end up with administration in different states if we have to do filings in different courts. So all things to consider. If you have fiscally irresponsible or immature beneficiaries, trust again will allow you to manage that money over a longer time horizon. Trustees are fiduciaries. Their job is to follow the rules and comply and make sure that they're looking out for your best interests if that's what the trust it says. That's the same for a personal representative, right? They're going to have to fulfill their fiduciary responsibilities also. So you want to make sure you've picked a person or an entity that actually has the ability to comply and complete these duties. Do be careful who you pick as your trustee. Don't just pick your oldest child. If they've had some issues with money, remember that when you wake up from the coma, you want to feel like everything was okay and your money's still there. So just make sure that you are thinking about who's the right person or the right entity for that. You probably want to make sure there are provisions for removing and replacing trustees. People get old, maybe they're not our friends anymore. Maybe the beneficiaries need to have some control over who the trustee is, even if they're not going to be the trustee. If you have young beneficiaries, minor kids, you might want to think about a corporate entity or a licensed fiduciary to act as the trustee, figuring that they'll still be around when maybe your brother or sister or nieces and nephews might not be able to be in that role. Because we want to make sure we have somebody who's going to be alive long enough or around long enough to comply with all of the terms of that trust. I did want to say, which is not on one of my slides, but sometimes probate is really good, and sometimes you want to do a probate even when you don't have to. For example, probate means that we have to provide notice to creditors. That means that we cut off any creditors' claims that might be out there in the world. So maybe your loved one didn't do a very good job of keeping good records, and a probate will kind of give us a statute of limitations on those creditors' claims. So sometimes that makes sense. If you have a very small estate and you didn't do a will or a trust, and we had to do a probate, but the amount the amount that you have is low, so $75,000 total of assets other than real property, or $100,000 of equity in real estate, we can do something called a small estate administration. For real estate, you have to wait 6 months before you can file and transfer that property. For anything else, then you can do that. I think it's within 72 hours to sign that affidavit and then be able to have access to those assets. So there are some other techniques in the event that you didn't do planning where we can try to get your assets to your what are called intestate heirs. That is the people who would receive the assets pursuant to our statute. So I hope that this has been helpful. I don't know whether we have any questions. I'm happy to answer them. Also, if you call because you'd like to talk to me, which would be fantastic, we just want you to know that there is $25 off as long as you tell us that you heard about me or saw the webinar, even if you already know me. So I really appreciate you all joining me today. I hope that it was informative and that you learned something maybe you didn't know before. I hope next time I'll actually be able to see you and have an opportunity to give you a big hug. Let's find out from Sarah if we have any questions.
Hi. So we have one question, and it looks like you touched base a few times in regards to probate. So we have someone asking if you could briefly explain what a probate is.
That's a great question. Thank you for asking that. So probate is the process of taking an asset that's in a deceased person's name and getting it to somebody, the personal representative, who can then make the distributions. So it seems like it's this big mystery, but essentially we have to file a bunch of papers with the court, and either if we have a copy of the will or an original, get that filed as well. And then the court will appoint the personal representative. Again, if we might have to have a hearing if there is a copy of the will, or if there's no will, if all of the heirs are unable to agree on who the personal representative should be, then we would go to court to get a personal representative appointed. And then that personal representative gets something called letters of appointment. And that's kind of their walking around paper to go to the bank and say, hey, I'm the personal representative. Emily's deceased. I need access to her bank accounts. We get a new tax identification number for the estate, and a new account is opened so that the assets can be deposited to that new account. And then that personal representative can file the final tax returns, get the house sold, deal with the personal effects, make the distributions to whoever the beneficiaries of that estate are. And as I said, in a probate, we also publish notice to unknown creditors in the paper, and we would send an actual notice to creditors we know about. So if there's a credit card bill and we have that, we would know that's a known creditor, and most likely you're going to try to negotiate that debt down if at all possible. So that's kind of how probate works. But if you have another question, by all means, put that in the chat box, and I'm happy to try to answer it for you. Any other questions, Sarah?
Yeah, I have a couple more that just came in. Someone is asking if the trustees will be charged any costs or fees during the probate process.
So that sounds kind of like two different questions. So I'm going to answer it as best I can. And if I missed it, just write back in the chat box and I'll try again. So one of the questions that people often ask is, are the trustees, the personal representative, or the heirs personally responsible for the debts of the estate or the debts of the deceased person? The answer is no. The estate has to pay its own debts before distributions are made, or the trustee needs to pay those debts out of the trust assets before distributions are made to the heirs. The trustee typically can take a fee, as can the personal representative, for acting in that capacity for the work that they're doing. So they could get paid for being in that role. In a probate situation, we have to file a compensation schedule with the court so everybody knows what they're going to get paid. And in a trust context, we have to provide 30 days notice to the heirs so they understand that there'll be compensation to the trustee. So I hope that answered the question.
Okay, we have another one. While the trustee is, okay, let me see. While the trustor is still living but not acting as trustee, what type of financial reporting is required for the trustee to give the beneficiaries in a family situation?
So I should have said at the beginning that I'm giving you general legal advice, but I don't know your particulars and I don't represent you today. But a general answer to the question would be that the trust became irrevocable probably when the person who's the trustor is no longer the trustee. I'm just guessing that that's why they're not the trustee anymore. They, however, remain the primary beneficiary of that trust. So that primary beneficiary would be entitled to get accountings and understand what's happening with their funds. Most likely, what we call the qualified beneficiaries, that is, the people who would take when that person passes away, are probably also entitled to reports so they can protect their interests once the trust is no longer irrevocable, because we know that they're now known beneficiaries, so to speak. And if that primary beneficiary, the trustor, is now incapacitated, notice would need to be given to whoever that person's agent is, so to speak. But of course, if it's the same as the trustee, that's not overly helpful. So I hope that answered the question.
Perfect. We had one last question come in, if that's okay.
Of course.
If there's a beneficiary deed recorded against a house and the owner passes, but there is still a mortgage on the house, what happens to the mortgage?
Nice question. So unfortunately, we don't get to avoid the debt because of the beneficiary deed. The lien is still against the real estate. So if the beneficiary of the beneficiary deed goes to sell the property, the loan will have to be paid off first. If they're going to keep the property, then they would need to either refinance or continue to pay the loan that's on the property, depending on the terms, in order to retain the property and not have it go into foreclosure. The same thing with a trust. People also often ask me if by putting their house in a trust, will that avoid creditors? And the answer is unfortunately not. If you still owe money because it's your trust and you can put your hand in the cookie jar, so to speak, the creditors can still come after you, and the loan against your house remains in place. Otherwise, we'd all buy a house with a huge loan, put it in the trust, and say, okay, well, now I own it, and you can't foreclose on it. So having a trust or a will doesn't stop litigation if we have upset beneficiaries or creditors, and it's not going to stop those creditors' claims either for the most part. So that's how the beneficiary deed works as well. That loan would remain against that property, and either has to be paid, refinanced, or paid off at the time of sale. Any other questions, Sarah?
One just came in. So, can the beneficiary of that beneficiary deed keep paying on the original loan without having to qualify?
So my experience has been that the lender is more concerned about getting paid than where the payment comes from. So, and if it's a immediate family member, I believe there's a federal statute that says they can't foreclose on it as long as the person continues to pay the debt. So I haven't had a circumstance where there's been a loan against a property, the guarantor of the debt is deceased, somebody else continues to make the payments, and the bank forecloses on the note. So I think you're pretty safe in continuing to make the payments. If you can refinance, so you know for sure it's yours and nobody could take it from you, of course, that might be the best approach. And right now we have great interest rates, so you might end up with a better loan. But I've not had the experience where a lender has foreclosed as long as they're getting paid on the debt.
Great. That's all
Any
I
other
have
questions?
on my end.
Okay.
No.
Well, again, I so appreciate you guys listening and attending and having an interest in the topic. These are two presentations that are coming up. So Jennifer Kupiszewski, my law partner, doing a presentation on August 19th about conservatorships. And then on the 26th of August, I have Lori Nissen from Banner Alzheimer's Clinic talking about dealing with difficult behaviors for those who suffer from Alzheimer's. So I hope we'll see you then. I hope I get to see you all soon. And thank you again so much for joining. And we'll talk to you soon. So thank you.